Hello, I'm sitting with Jandy John, an estates and trust professional from Concentra Trust. Thank you for joining me here today.
It's an honor to be here, Simon. Thanks for having me.
Oh, it's a pleasure. Always good to see you. Always good to see you.
Great.
Could I know what you do, but could you please explain what your role is?
Okay, so in essence, my title is Director of Estates and Trust at Concentra Trust. I've been in the industry for about 30 years, and we are estates and trust professionals. We handle fiduciary obligations. So when a person passes away, the trust company could act as executor to settle the estates and continue the legacy and outline in their wills.
So basically, when somebody does pass away, you and your team would be able to come in and help to act on their behalf to settle their affairs.
That's correct. We work with them too when they're alive to ensure that the planning is in place. So if they need a power of attorney or if they need trust or their estate planning, we work with them cohesively to add that benefit to them while they're alive and when they pass away to continue on to act with them and their families to settle their estates.
So it's been a number of years now that
Yeah.
we've been working together.
Yes.
And almost every time that we interact, I learn something. If we're thinking about planning before somebody passes away, making the considerations about how is it that you organize your affair, it's very difficult sometimes. And after somebody passes away, it's also very difficult for the families that are mourning to get through everything that needs to happen. What would be some of your thoughts on the role and how you manage that with people?
Well, one thing I say to everyone is the only certainty in life is we're going to all pass away. And we can either plan for when we're not here and can make decision, or we can let the family take care of it. By having the family take care of everything is you're leaving them with their grief and as well as settling complicated things that they have nothing or no input on or just good to say. What I do recommend for family, and I do understand their cultural differences and their difference within every family, is always communicate with your family. Let them know what your plans are. Let them know how you plan to be buried. Let them know who is the named executor. And if there is a named executor, let that executor know where the documents are, how to locate them, where your keys are, where your passwords are, where you worked. So have that whole plan and ensure that the family knows. Family meetings are very, very important. I mean, sitting down over dinner one night and say, hey, this is what we want to do and this is how we want it done. And that way you can eliminate bickering when you pass away and allow the family to really grieve and mourn the loss of the loved one.
One of the most heartfelt experiences that I've had in this business happened actually a very long time ago. It was probably around 2003. I was a planner at one of the major Canadian banks, and I had somebody come in, a gentleman that was probably late 40s, early 50s. His mother had passed away and left him an envelope with all of the information about where she was to be buried, about where all of her assets were. Also left him about $5,000 in cash to make sure that he could settle affairs while everything was being sorted out with his estate. And he was so overjoyed, like not overjoyed, he was grateful
Yeah.
that he didn't have to make a lot of decisions at that point in time. So I know how impactful it can be. Um, Now it's hard for people to discuss these things. Like this is one of the biggest stumbling blocks that I've found. How do you manage those conversations, and how do you encourage people to go down that road to think about these things?
Well, we have to look at things. I mean, people make a lot of assumptions. The biggest assumption I hear is the government will look after it. I hear a lot of assumption, oh, I'm married, my spouse will get everything. It doesn't work that way. It's different laws to govern what happens when you pass away and different ways that things can be settled. So it's a very difficult conversation to have, but it's a conversation I encourage people to have. I know we talk about differently with marriage contracts. We talk about different aspects of life. So it's part of that conversation also. Any life-changing event, if you're going to be married, if you're going to be divorced, if you're going to have children, this is all a part of the conversation. And I wish there's a magic wand I could wave to say to make it easier for people to talk about. But it's a conversation that really needs to be had, because when you pass away without a plan, it's going to cost your estate, it's going to cost your family a lot of grief, it's going to cost a lot of money, and it's going to cost a lot of time. I've had estates where there were millions of dollars left with no plan in place. And what happens is, who inherited was a distant uncle living in Ireland who inherited funds that should have gone to family members here and friends and charities. So I know it's a very difficult conversation, but if we take it piece at a time, if you're going to talk about grandchildren, here's a lead into it. Or the grandchildren are coming along, I want to set up a trust for my grandchildren. Let's start that conversation. And then it becomes a little easier the next time to a different conversation.
You're talking about like the potentiality to handle wealth transfers, right, between generations. Um, is there ever a time where people don't need to have a will, or that this is not important?
I would like to say yes, but the answer is no. I mean, even if a simple quote unquote, this is a word I don't like when I talk about estate administration, simple. A will in place is a person's way of controlling what happens to their assets. You can pass away with $20,000. You still have assets to be administered. You still have tax returns to be filed. You still have closure. You still have identity that's in the world that needs to be closed and shut down. You still have that's coming to you that needs to be canceled. You still have credit cards that needs to be canceled. Unless you leave someone, an executor, to make those decisions, no one can speak for you if there is no will in place. So it's not just about the finances that you have and leave behind. It's all the other stuff, there's identity theft, there is bank accounts, there are point cards, there's cleaning out refrigerators, there's a lot of different other things that goes with it, as well as transfer of wealth.
So when you do pass away, you need to have somebody help to administer that estate.
Correct.
How do you choose the right executor or trustee?
Well, the rule of thumb when choosing an executor, you have to choose someone that is trustworthy. Working with a trust company, I like to see a trust company at some point as an alternate or as someone who's there. When you choose an executor, that person cannot have a criminal record. They need to live in the province that you reside in. They also need to know their responsibility as an executor, because administering an estate, there are about 300 different things to do to completely close out an estate, and not knowing and understanding what you need to do. A person passing away can leave their estates open indefinitely to any kind of liabilities. So choose someone who's competent, someone who is not your same age, because everybody aged in the same way. Choose someone that's just trustworthy, who will communicate with family members, who will allow family members to grieve without adding undue pressure and stresses onto them, and someone that that is going to really work in accordance to how the will is written, not to go and deviate from the wills. Oftentimes we see people try to make different decisions, not on the will, because they think it's going to be better for, and it turns out can it be very cost effective and not cost effective for the beneficiaries left behind. So the rule of thumb is choose someone that is younger and will be competent at the time of death. Choose someone in the same jurisdiction, because if you choose someone outside of the country or even outside of the province, it adds a different layer of tax complications. And trustworthy, of course.
Trying to help guide people with those decisions, oftentimes you find people that are outside of those bounds. When should somebody consider professional, like hiring a trust company to do it, rather than appointing a direct executor?
For spouses, I like to see spouses appoint each other and then have an alternate, the trust company being alternate. The rule of thumb for me is, if you do not have anyone that resides in your province, then a trust company makes the most sense. If you have a blended family situation, that makes a lot of sense, because it adds layers of complications. Complex assets also, I mean, could be holding companies, secondary properties, that adds a different level of complexities. If there's family conflict, I know people don't always want to speak of family conflict, but it does exist. Every family, there's always one, right? So if there is some kind of family conflict and you know of it, it's best to leave a trust company. And the trust company can also act individually or with with a family member. So you have that extra layer there that the family member can have those touch points, and the trust company is completely neutral in decision making. So in all instances, trust companies make sense if not directly alone or with acting with a family member.
If you have a property that's in another jurisdiction, how is it that you should be planning for that?
There's several ways to plan for that. I mean, as I said, estate planning is not just about a will. There are different facets of an estate plan. You can set up a trust for that property in a different jurisdiction. And that helps because it avoids probate and that asset is completely private. Because when probate is filed, it becomes public property, everybody can see that asset. So that's one aspect of it. You can plan around and do a trust the different ways, and different tax mechanisms and also in place. You can gift the asset before passing away. And then there is also the will. The will can be a Canadian will to cover the property in a foreign jurisdiction, or you can make a will in the foreign jurisdiction also to govern that property. Because in Canada, say for instance, if the property is in Arizona, we have a lot of those Canadian owning homes in Arizona. What an estate trustee has to do now is to get an agent in Arizona to represent the Canadian estates to ensure the property is sold and all tax filings are in place. If a separate will was in place for just Arizona, that executor in Arizona can just close out the estate in Arizona, liquidate the property, and transfer the assets to the Canadian estate. If that property in Arizona wasn't a trust, that can continue after death, because that trust can continue after death and could be left to family members to continue the joy of the property until such time as the trust winds up. So there are different ways to plan that out.
And what we've seen again in a lot of instances in a lot of families is that there may be some people that are left behind that cannot care for themselves and cannot manage their own assets for one reason or another.
Yeah.
How should we be thinking about that, and what can we put in place to help make sure that those people are taken care of?
Yeah, a will also has the benefit of person can make a testamentary trust. And a testament trust will govern the individual, say with a disability or with some addiction or any other complexities that they can't get the money. They should not have use of the money right away. In Ontario, we look at ODSP, for instance, and we do not want any of those benefits to cut off. So the use of a Henson trust through a will really helps with that, and the trustee can continue that trust in a lifetime until that trust no longer is required for the individual. So the use of testamentary trust really helps with that, and it gives a plan for the person receiving the income from the trust in terms of how they live. There's income and expense analysis done to ensure they have the income they need. And for instance, if it's a disability trust or a Henson trust, it will also work with their care provider to ensure that their benefits are intact, their housing is in place, and income and expenses done every year. So they have what they need to live on and to live in comfort also, not to scrimp and save so they can't live in comfort or what they've come accustomed to.
And the trust company can help to manage those assets?
Of course, the trust company acts as trustee, and as trustee, you have to have all of your fiduciary obligations as trustee, ensuring tax returns are filed, ensuring you work with the investment advisor to review what income is needed and what income is generated, ensuring that the person living on that trust has a degree of humanity still about them, so they can still live and not feel as if they have to come to us and have their hands out begging for funds. We have to give them their humanity still when we work with them.
Um, a lot of people will do some research on the web,
Yes.
figure out how is it that they can write their own will.
Oh,
Is there, could you talk a bit about that?
I'm a purist. I have 30 years of experience, so I've seen holographic will, that's the handwritten will. I've seen the computer wills. I've seen it all. A will is not just a will. Going to a lawyer to draft a will gives you advice also. The lawyer will give you advice in what you're thinking. If you're thinking, I need to leave money for my niece and this is what I want to do, the lawyer will explain to you the pros and cons of what you're doing. With the will kits, it's you plug and play, you plug and play, you plug and play without any advice. Needless to say, the will kit does work for certain individual. It does work for certain individuals. Say I'm a single person, I have no children, I'm leaving everything to X. Yes, that's simple, that can go. But if there's any other if you're leaving to more than one beneficiary, if you have any other complexities, if you own a home, that's a complexity in itself. It's understanding those, then that will kit does not make any sense.
One of the tips that you had given me that I just really want to amplify because I was guilty of this myself is do not leave your will in a safety deposit box.
Yes.
Could you
Yes.
tell us why?
Yes. Many times. So when you pass away, the bank closes everything. Your accounts are locked and everything that you have access to no longer exists. So when the will is in the safe deposit box, it's hard to get to because the bank may not let you in to it until you have a copy of the will naming yourself as the executor. So you need proof that you are the executor to go into that will to remove anything. You may have a copy of the will and they may let you go in, but you can't remove anything from that safe deposit box. So the original will should always be kept different space to keep it. If you're naming a trust company, the trust company can hold the original will. If your lawyer has that facility in a fireproof area, they can keep the original will. Or if you have fireproof filing at home, you can keep it there. It's good to let your executor know where your will is kept. Always let your executor know where your will is kept. And if you use a trust company, you get a will card that's you carry in your wallet. In case something happens, contact X, Y, and Z, and they will have that information. But yeah, safe deposit box are great for coins and everything else, but not the original will because it's difficult to get access to that original document to file your probate application.
And one of the things that we try to do here, whenever we do a financial plan, is to get a copy of the will so that we understand what the person's wants and needs and desires are, so we can help them plan their finances around that. It's important to communicate to your family members, like who are the people that might know a bit of information. So that is something that we do is make sure that the people that the next generation knows that they can reach out to us and we'll at least have an idea of where things might be.
Exactly.
So we've covered a fair bit here. Do you think that there's anything that is very important that perhaps we didn't talk about?
Just let everybody know the absence of planning is no plan. And when there's no plan in place, the laws of intestacy comes into play. It's not the government coming in to take your money. It's not, oh, my wife will look after that. Oh, my kids will inherit. There's a whole different way of who will inherit and who can look after your assets if you leave no will behind. And when we talk about the plan, there's a whole gamut of a plan, of good estate plan. A good estate plan will have a power of attorney. Power of attorney to me is one of the most important document to have because you never know when something is going to happen to you and you become incompetent and no one can speak for you. It's not automatically a spouse takes over. There has to be a long drawn out application to the courts for somebody to speak for you. So having your full estate plan, having your power of attorney for both property, which is the finances, personal care to make medical decision for you. If you have a complex assets, like for instance, several different real estate properties, holding companies, you may want to set up an intervirus trust to manage those properties while you're alive and do some tax deferral in your lifetime. You may want to do that also. And then you have the wills. In Ontario, we can do primary and secondary wills. Again, tax efficient, cost effective, and cost efficient. So if no planning is in place, everything goes out the window and it's just the laws of intestacy. Everything rolls into your estate, foreign assets, local assets, and then it's a divide amongst the laws of intestacy, meaning it can go to your parents, it can go to anybody who is alive at that time. So planning is very important to put in place and having those conversations with family members.
I have to make one point about what you just said about the powers of attorney, because we all get so hung up about money
Yes.
and about assets,
Yeah.
but we don't talk about ourselves and our
Yeah.
health and decisions around what decisions should be made
Yeah.
if something were to happen to me and I could no longer make those decisions. So there's a whole class of like, basically, if something happens, then there's somebody that is my power of attorney that can make decisions for me. But there's certain decisions that even they cannot make.
Correct.
Could you talk about that a bit?
Yeah, for instance, there's two types of power of attorney. There's a financial power of attorney, and then there's the personal power of attorney. A person who's the personal attorney cannot make those financial decisions, and they should work together to ensure that that person, we call it the grantor, has what they need in terms of living expenses and in terms of what they can survive. Do they need nursing home care? Do they need 24-hour care? And making those decisions for them. The absence of those documents, there are two routes that can happen. The public guardian and trustee, which is the Ontario body, that can take over to make those decisions. And when the public guardian and trustee does take over, there's no other say from family members. It's what the power of attorney decides and how they decide to do what they need to do. So again, it's important to appoint your guardian for your power of attorney for property and your power of attorney for personal care. And in my opinion, there should be two different, because people want to dismiss the emotional side of things and caring for someone. So caring for someone emotionally and caring for someone financially, they sometimes they take a different mindset, because the financial is black and white, is they can afford, they can't afford it. The personal side is, oh, I want them to have it. I want them to have it, not knowing that if they can, I can't afford the care.
I've had this experience a few times. Again, when we're working with people, we're working with people for decades,
Yes.
right? So there's families that I've helped for 20 years, and on a number of occasions, people have grown old and passed. And I've seen a lot of people that, as they move on through that experience, they end up, some of them have chosen that they're in too much pain and they want to be helped along. That sort of decision cannot be made except for by that person. So if they're no longer, there's been some cases where people are very distressed, in a lot of pain, cannot make decisions, but they could have provided for some options and choices in their power of attorney.
Yes.
But their power of attorney can't make those decisions for them. So as difficult as these things are, if you do have the ability to think about that and document what you would like to have happen in different circumstances, it might make all the difference in your life and even the people behind, because sometimes the care can get extraordinarily expensive as well.
And that's true, because when you no longer have the capability to make a decision, there's only one thing that you have. It's your is your power of attorney and your will. So those are the documents that will allow people to know what decision you want to make. And in the whole estate plan, there are different things, the memorandums and letters of wishes and every other thing that can speak for you when you're no longer able to speak for yourself.
So there is so much still to unpack, and I'm sitting here thinking I could keep on going for ages and ages. If this, then that. I'd like to thank you very much. If somebody wanted to reach out to you, how would they be able to do that?
Emails or telephone would be great. I'm more than happy to talk to anyone. Again, I'm very passionate about this because I've seen so many cases where someone's hard-earned money and has gone through lawyers and different places because of not putting things in place, not putting that plan in place correctly. So more than happy to talk to anyone, just an outreach, or even if they need just a direction to a good lawyer, more than happy to do that also.
Yeah, that's great. Jandy, thank you so
You're
much.
very welcome.
And look forward to the next time we speak.
Thank you. Thank you for having me. It's been an honor.